Um, First of all, I would like to thank all those enthusiastic people who are still here and listening to this topic, which might be a bit dry sometimes, but I will try to be very straight to the point. I have 10 minutes. One might ask, why am I talking about this issue, even though I'm from the Hungarian Intellectual Property Office and not from the Ministry of Justice. It's because in our system we also have the possibility to take part in negotiations on the EU level in the Council working parties. We also had the possibility to contribute in the drafting of the implementation of this directive, and we will have the nice task to supervise the CMOs and to make sure that they comply with the new requirements that are set out in the directive. As in positive trainings, people many times say that it's a good thinking that you should not call a problem, but you should call it a challenge. Well, for us, the implementation of the directive was a great challenge. Now we are in the part of trying to use it, but I will like to show you those neuralgic points which we had during the implementation, what we had to face with, not in much of a depth. The first problem with the directive is that it's quite a huge one, quite a casuistic one, but it's casuistic not in a consistent way, but some parts are quite liberal and leaves open possibilities for the member states to decide, and other issues are very, very casuistic, which are quite hard to introduce and quite hard to then make sure that they are complied with. As for the main points which we had problems with, the first thing was the definition of a collective management organization. The directive is quite liberal on this issue. It says basically everybody who represents a right holder, more than one right holders, and does it either on a non-profit way or under the leadership of the owners, of the right holders, can qualify as a CMO. Well, in contradiction to that, Hungary had quite requirements for CMOs. They have to comply with many requirements. They have to be representative, but I will get to this point later on. The next big issue was the structural rules of the directive. We have a special legal form for the CMOs. They can only be associations, as we heard in Czech Republic. There was a similar issue. And of course, the governance and royalties, which are affected by the directive. We have, like in the Czech Republic, a special system. In our system, it's always the Ministry of Justice who has to approve the tariffs of collective management organizations, and they are approved in an annual basis. So each year, the CMOs have to provide their proposals, which our office provides. Analyzes them and says that and advises to the minister whether it should approve it or not. The supervisory regulation in the directive are not very detailed. Basically, they set up such a general requirement for the authorities that they should make sure that all the CMOs are in compliance with the regulations of the directive. However, there's a cross-border effect of the directive, and it encompasses the way how the authorities have to act together in order to supervise these cross-border effects. These are the main things which I will cover. Of course, we had other problems with regard to the licensing of non-commercial users and other tasks or independent management entities, but I will not bother you with it. Maybe a few words before the implementation about the system which we had, why we had the real problems with the directive. As you see, we had three kinds of collective management in Hungary. The first one is the compulsory way, which means that in the act it's set out in relation to some rights that they can only be licensed through collective management organizations. It's due to the fact that in these cases, right holders cannot easily or cannot in any way provide licenses. As for the collective management prescribed by law, it's a way when even though the lawmaker thinks that the given licenses cannot be given directly, there should be a possibility for the users for the right holders to opt out from the system and provide licenses directly themselves. And the third way is the voluntary way, when writers just decide that they want to license the use of their works by a collective management organization, they form one. All these kind of collective management organizations have to be registered at our office. They are checked, all the requirements which are set out in the law are checked, and they are approved and registered. In this system, we had 9 collective management organizations, so a bit more than the Czech Republic, but not many. It's due to the fact that we also had a monopoly, which we demolished a few years ago, so now anybody can be a collective management organization. I mean, anybody can form one. As for the consultations, very briefly, we had 3. The first one was at the end of December 2014. The main focus was whether we should do the implementation in a separate act, just on focusing on collective management, or amending the Copyright Act. We decided the latter should be the case, so we will have a separate act. As for the second part of the consultation, we went into more details how the questions which are raised from the directive should be tackled with. And March 2016 was the consultation with regards to the act itself, the draft. All these, I mean, in this regard, the first 2 consultations were, the result of them was that the current system of collective management should be kept. It should be maintained, even in the case of extended licensing, which I will talk about a little bit. Oops. So, what the solution about extended licensing was, why the issue comes up. It's basically because the directive does not really deal with extended licensing. Extended licensing, as you might have heard today or yesterday, is the licensing when a collective management organization can provide licenses even on behalf of those right holders who are not in a contractual relationship with them. So they represent even those right holders who they do not know. So this is a system which is very useful in our, we think it very useful and very important that it should be kept. And we had to somehow make sure that the requirements of the directive and our system can somehow be put together without colliding with EU law. So as a solution, we got to the solution that a representative collective management organization should be formed, which would be a collective management organization that is a society that shall represent a significant number of the right holders, which means that if you want to provide extended licenses, you have to have a representativeness. You have to have such a system that many right holders can have a say in what you do. This organization shall be licensed by the Intellectual Property Office, and its tariffs, as it used to be, shall be approved by the Ministry of Justice. So this does not mean that that all collective managed organizations have to be representative in Hungary anymore. This means that in the case of voluntary collective management or systems, the collective managed organizations which are not representative can also provide licenses, and in the case of compulsory and prescribed collective management, only a representative can be the one who provides licenses. So as you see, we could somehow maintain our system. What we had to open, and that part is where we open to the European legislation. The end of the implementation was 3 legal norms. The one was the Act, which I referred to. The second one was a government decree, which is much more in detail. It deals with the procedures in relation to collective management. And the third decree is about the fees in relation to the procedures that have to be paid to our office. And about the current state of play, we are in the phase of trying to use what we have put together. And it sometimes is quite difficult. The CMOs have to comply with the new requirements, and also us will have to be sure to make sure that they keep them. Many questions and inconsistencies arise. We try to negotiate and try to discuss with the CMOs. this is the case in the European level also. As we heard, maybe the Commission will start to discuss with all the member states on the issues which are raised from the implementation. And our system, there are signs that the system is opening up. New independent management entities are knocking on the door. They want to enter the market. So this is where we are. The challenges are yet to come. Thank you very much.